morning, Ms. Jill.
How are you?
I'm great. How about yourself?
Good. We communicated yesterday was her deadline, so you got her email back.
Got
Which I sent to you.
You say you just sent it to me?
No, I sent it to you last night. I also texted you last night and tried to call you.
I missed your call. Which one you talking about? Which email you talking about? Because I got a few.
The one where she said to me, "This is my authority."
Okay, all right. I probably got everyone except that one. I probably just didn't read it. But okay, what else? What else?
It was the last one that I sent you.
Okay, no problem. I believe you. So what is she saying?
Hold on, Carl. I'll put you on speak because I gotta look at my phone. It's downstairs.
Yeah, I'll pull it up. I'm driving.
Okay, so basically what she's saying is they have authority at the 200,000. Finally, there was some back and forth about one of the people who had to sign off in the Attorney General's office, because for the approval, it's not her. It has to go to Office of Risk Management, Division of Administration, Sedgwick Insurers in Tennessee, and then the Attorney General's office for approval, in addition to state police. So all of that happened, but apparently one of the people at the Attorney General's office had a death in his family, and so therefore the issue was that they couldn't get final approval. So the email I sent you last night is that they are authorized to accept the demand of 200,000, but then they have these following terms and conditions: to settle all past and potential future EEOC claims, all past, pending, and potential, which is normal; to accept your resignation in lieu of termination effective November 23rd. They don't want to remove the phrase "in lieu of termination," but don't let that hang out because I have a plan. They will not remove, withdraw, rescind the employment discipline. Let's see, and they want you obviously to not seek employment or reinstatement with the state police in the future. So here's my plan. I know the one term and condition you're most unhappy about is likely the one as it relates to the above business. Right?
Yeah, I'm listening to you, but I was gonna let you finish before I responded.
So we have several options. Here are the options. Number one, we can approach the commission and attempt to get them to put pressure on state police as it relates to the non-monetary components of damages. Or two, and frankly, my preferred option is approaching our magistrate judge and asking her for a brief settlement conference to resolve those last issues. And that's my preferred option because I think it's the best option.
Yeah, I'm not gonna agree to that.
Well, you don't really have a choice, Carl, because the court has ordered a settlement conference in your federal case. That's something that already must occur.
No, that's fine. I'm not talking about that part. As far as going to the magistrate and asking for.
Right.
Yeah, I'm not talking about that part. I'm not going to agree to them.
Are you talking about their offer? No, I agree.
Yeah, I don't agree to their offer.
So what I would recommend that we do is allow me to reach out to the magistrate and see if we can get a very quick, like ASAP, settlement conference with the magistrate and see if we can't work out the non-monetary term. It seems to me like it's a police, but you have to be.
Hey, you still there with me?
Yeah, I'm here.
Okay, all right. It's going out on me. Yeah. So the deadline was yesterday. They missed the deadline, and
they missed the deadline, Carl.
No, they missed the deadline. Jill, how did they make it?
Because they sent the email last night responding to your offer, and they do have the authority at the 200,000. They have that. They've met their deadline. That's not an issue.
No, well, the issue is the non-monetary things that we put up on the table. That's not agreed upon.
All right, which is why I'm suggesting to you that I think we all go visit with the magistrate judge and have a settlement conference and let them talk to them about the non-monetary stuff.
Yeah, but doesn't that mean like until that time happens, I have to agree to the 200 and also agree to the 200 and also the stipulations and the offers that come with it.
No. All this is going to be is, dear magistrate judge, we have exchanged offers on the table. The parties are at a loggerheads, at an impasse as it relates to certain conditions of settlement. We would like a settlement conference with you to see if the court can help facilitate the settlement. That's what that is.
Okay. So what happens? What happens to the what happens to the EEOC case in the meantime?
There's no Carl. What she is likely going to do is kick it back to enforcement. But you need to understand the EEOC doesn't investigate anything. They can't. That was one of the emails I sent you.
Yeah, I know, but what was the point of filing the EEOC claim if they can't?
Title VII requires you do so. It requires that you file paper with the EEOC. Period. That's a legal requirement in order to pursue those claims. And the only Title VII claim that you have really is the retaliation on particular racism. The state law claim does the same thing, but the EEOC claim is kind of like a belt and suspenders. It's there, but it doesn't give you much more. The reason it doesn't give you much more is because you already have a claim against Lamar Davis, right? Pending for, the violation of your civil rights. Your EEOC charges, such as they are, can only be brought against your employer. Because your employer is a state agency, you cannot recover punitive damages. That's a federal law that says you can't do. So what you recover with your retaliation claims under the federal statute for the EEOC stuff is the same thing that you already can recover in your pending claim in court. Compensatory damages. Follow me? So there's nothing that is impactful on either side of this equation. Nothing.
Okay. So what's the status of the commission hearing? I know I had the termination hearing coming up.
You do. That's still on the docket.
Okay.
The only one we to upend was the one as it related to the enforced leave.
That's
Your station hearing is set in October, I think, for some point in time.
October 2nd.
Is it the second? Yeah.
No.
I don't think it's the second.
No, I was asking. Okay.
No. It's late October. Let me see if I can search it. I'm pretty sure it's late October. In fact, I know it is. Because I looked at all that when we were talking about the settlement negotiations and what that was going to look like. Let's see, right. With Cavalier with that 9-step. Sorry. I hate the calendar. Anyway, I believe, Carl, that the hearing on the termination was late October. But for some reason, I can't pull it up. I'm looking for 11th, or let's see. Or since the federal stuff. I don't know. I'm sitting in front of my computer.
Okay.
But the point is that it's still on the calendar. They got it upended was the enforced leave thing. In terms of the EEOC, there's nothing that's going to happen. They're not going to investigate your charge no matter what happens, because they can't. Because I think I sent you an email or whatever. They get thousands of charges on an annual basis, and there were 3 investigators in the New Orleans office.
So you're saying there's no possible way they're going to investigate it, or it's a slim chance because they don't have the number of investigators to do so?
Right, there's no way. I can tell you from my experience, it would be extraordinarily rare if they did. Extraordinarily rare. And then I heard a couple of days ago, because I was talking to one of the EEOC people, intake officers, on another case, and what they're currently looking for, the priority in Washington, are ADA claims, Americans with Disabilities Act claims. Each year, the U.S. government prioritizes which claims it wants the EEOC to investigate.
Uh-huh.
And so what they'll do is they'll go look through all the districts throughout the United States and figure out who's got what. You know, do you have an ADA claim that involves cancer? Do you have an ADA claim that involves, you know, this or that? Because that's the priority for litigation on that particular date. What they're looking for.
Okay. All right. So right now you wanting to get in contact with the magistrate and
yeah, you have to anyway. It was ordered at the beginning of your case in federal court.
Mm-hmm.
Oh, thank you. Your hearing for the termination is November 10th. Okay. So, I mean, I think that it's helpful, Carl, because I really feel like we can utilize the magistrate judge to, I don't want to say force state police to really acknowledge the additional terms and conditions that we wanted and make this thing settle.
Okay, so what do we do with the first half of it? I know the non-monetary, we go to the magistrate, but the first half of it, with the monetary side, you can't agree to one without agreeing to the other. They come together, right? You can't just say, okay, I agree to the first half. But
they come together, Carl, but I also don't want to be unreasonable.
How is that being unreasonable?
Because it is. And what I'd like to be able to do is to be able to get in front of the magistrate with the settlement conference, which we have to have anyway. And I think the logical step is, all right, magistrate judge, if they won't agree to the non-monetary stuff, then they need to pay him more money. You follow me? I need to have that flexibility. And I certainly don't have a problem with that. They've got $200 on the table and not agreeing to our non-monetary stuff. Let's see what we can do. If it doesn't work, it doesn't work. We fulfilled our obligations to the magistrate and to the federal courts in having a settlement conference, and it is what it is.
Okay, and I'm just trying to be clear and trying to be thorough before I get off the phone, because I don't want to have to ask you a million questions, not to make you repeat yourself. But so if I say, okay, yes, I agree to what you're saying. So what I'm really agreeing to is, okay, hey, we take the 200 and the terms that come with that, all the things you said that come with that, and go forward and reach out to the magistrate to get
not what I'm saying.
Okay, all right, that's why I'm asking you.
What I'm saying is, we made an offer, they made a counter offer. Nobody has accepted anything.
Right.
What I'd like to do is get the magistrate involved to see if we cannot get you and state police to come to a mutually beneficial agreement to resolve all issues. That's what I'm saying.
Okay, and until that time, until the response and a date from the magistrate for us to sit down and do this, until it's figured out, is everything else on hold? The commission and
settlement. Your commission hearing is November 10th, so that's not been moved. And the federal stuff, we have deadlines that start coming up in January, so there's no issue.
Well, that's what I'm asking. I'm just trying to get specific answers. That's what I'm asking. If, say, the magistrate say, hey, okay, we'll entertain that. We'll set a date. The date ain't till March 2023.
That's not going to happen, Carl. That's not going to happen.
Okay, you're saying it's not going to happen, but you're not for sure on that. You don't know that for sure, right?
I am sure on that. Because if the magistrate doesn't have a quick date, meaning within the next week or two, then we just won't do it. And we'll move forward on all fronts. But what I'm suggesting to you is, we have an obligation to have a settlement conference with the federal court first, no matter what. That's part of the original order. That has to happen. You do not lose anything by asking the federal court to hold an emergency settlement conference, because we are, in my opinion, and I think it's right, close on resolving all issues. You follow me?
I believe so.
I'm not going to let anything get set that far out, and if it is, then, all bets are off.
Yeah. Because I just want to reiterate, I know I put in, writing to you already, but, the non-monetary is just, it's probably more important than the monetary to me, the things that I asked for, because I don't want to sit there and have in lieu of termination and all that. It just, I don't think that's something I want to, accept.
Look, disagree with you. I've expressed to the other side on numerous occasions the importance of the non-monetary, and you got a response. I got a response. We all got a response last night. It's not ideal. It's not perfect. What I suggest to you is, I think we get the 800-pound federal gorilla involved to help them see the light and the error of their ways and work out the non-monetary stuff. That makes a lot of sense to me. You know?
Yeah. Okay. Well, I'll let you know by the end of the day.
The mediator, she's good, but she's not a judge.
No, understood. I get that. I just, figure since, I wasted my time, quote unquote, doing the EEOC thing. I know it's the part of the process. You got to do it.
You're not wasting your time, Carl. If you had not filed with the EEOC, you would not have a Title VII retaliation claim. The difference between a Title VII retaliation claim and your state law reprisal claim is, under Title VII, all you have to have is possession of a reasonable belief that what was happening, that what you reported was discrimination. You do not have to prove that any officer within state police was actually discriminated.
Yeah.
Under the state law claims, you have to prove that there existed actual discrimination. You have to prove 2 cases. Under the federal Title VII thing, you only have to prove 1 case. That's the difference. Plus, federal law requires that you file with the EEOC within 300 days of the last act of discrimination, or you lose those claims.
Gotcha.
They don't do anything because, frankly, they don't have the resources to.
Okay.
But they set them up in 1964 as a clearinghouse, and back then the EEOC actually did things. But it's gotten so big, and the issues of discrimination so systemic, that the EEOC, frankly, has no resources by which they can investigate or do anything.
Or is at some point will Ms. Goff or the EEOC tell us, hey, we can or we won't investigate this?
No, all she is she is in the mediation, the conciliation section. She doesn't investigate.
No,
she has a time deadline that's established by the EEOC, the federal EEOC in Washington, that says, for example, when an investigator gets a charge, they have 10 days to process it, and they have to click off little boxes on their computer. That's where she is. She has an artificial deadline that was set likely by the EEOC in Washington, D.C. When a charge is referred to her for conciliation, this is the amount of time that she has to get it resolved. If it doesn't get resolved, then she steps back, and it goes back to quote-unquote enforcement, which is essentially nobody.
Yeah.
As long as your charge is pending with the EEOC, prescription or the statute of limitations as it relates to that claim is suspended. It goes nowhere.
Okay. So as of now, what answers, what questions did you need answered from me? Like as far as going forward?
I just wanted to explain to you what my thought process was in terms of let's get the magistrate involved now, and let's see if she can't broker. I think it's a she on your case. Can't broker resolving the remaining issues that the parties don't agree on. And I'd like the flexibility of, okay, if you're not going to agree to the non-monetary stuff, then you're going to have to pay more money. But I need an 800-pound gorilla to do that, meaning I need a federal judge person. The EEOC woman, Ms. Goff, nice, wonderful, but she has no power.
Yeah, I get that. I get that part. But, even a flexible thing of having, say they give me 3-4 more times more money. I still, I don't agree to that. It's the non-monetary, non-monetary.
But part of the issue, honestly, is I understand, I do, because I get clients that get dug in all the time. All I can do is express to you my experience,
right,
and what I think that this means, and ask that you not get hung up on terminology that really, in the grand scheme of things, doesn't mean anything for you.
It means a lot to me, Miss Jill.
But I understand that personally. I do. From my perspective, objectively, it's not as catastrophic as I think that you think it is. But what I'd like to do is be able to utilize the aegis of the federal court system and see if we can't iron out these last issues.
Okay, understood.
It's awful.
It,
And look, those lawyers aren't going to sit in there and tell a federal judge to go pound sand. It doesn't work that way.
yeah. And I mean the magistrate is going to happen. Whether it's nay from me anyway, because that was ordered, right?
Happen in 6 months from now, and I'm of the opinion. I think we should strike while the iron's hot, and we have everybody engaged, and everybody focused, and everybody in the same room. I mean, that's smart.
All right. Well, how about this? How about we let out commission hearings happen first? At least the ones.
No, I do not agree with that, Carl.
Why?
No.
Why not?
Because you lose settlement leverage. You lose all the leverage you have right now. The leverage you have right now is the great unknown. Okay, that's what you lose. And so my recommendation, absolutely 100%, is let's get in front of the magistrate and see if she can iron out these last issues. But why would you want to lose leverage?
I definitely don't want to lose leverage, but I mean
But you do.
Yeah, but they've been kicking me in my ass and still have intentions of kicking me in my ass, obviously. So I don't see me losing anything going to the commission and
leverage.
Say it again.
You lose a commission, 90% of your case goes out the window.
I lose what?
You absolutely lose leverage. Right now, you have the pressure of the termination hearing is set for November 10th.
Correct.
Right now, you have the pressure of an existing federal lawsuit and no decision on the motion to dismiss. Right now, you have all of those pressures on your side. The unknown. I mean, that's what I need. I would like for you to understand is that you're in a good position to settle your case now, because we're not having to fight if the commission goes south in the Court of Appeal on whether or not your termination was appropriate or inappropriate.
But my thing is this: why would I settle? Or be willing to settle on terms that I don't agree to? I don't agree to those terms.
I'm not asking you to do that, Carl. All I'm saying is, let's go talk to the magistrate and see if she can help them see the light and agree to the terms that you will. That's all I'm suggesting.
Yeah, I just feel like we miss out on things that that comes out in the commission hearing and all those things that we can possibly use later on. If we have to go forward and fight. I mean, it seems like we have to go forward and fight because
the commission hearing's not going anywhere.
It's going to.
But I need you to trust me, honestly.
Yeah, I understand that, but I'm not comfortable, and I'm not comfortable, and I'm not comfortable for a reason.
You're not doing anything, Carl, except all I'm telling you is we need to get in front of the magistrate so she can help us secure the non-monetary stuff that you want. And now is the time to do it.
Yeah,
That's what I'm telling you.
Yeah, I mean, it's just all backwards for me. It's just it doesn't sit right. But I'm not going to keep spinning your wheels. I'm just let me go and sit with my thoughts for a while, and then I'll call you back later today.
I don't have a lot of time because I really believe we need to get the magistrate on board and we need to get on her calendar.
Well, you're saying you don't have a lot of time, Miss Jill, but this is my life, though.
Carl, I didn't say I don't have a lot of time.
That's what you just said.
We don't. You and me, I said we don't have a lot of time.
Okay.
That's what I said.
All right. Well, I need some time to think about it, Miss Jill.
Okay.
I need time to think about it because this is my ass being kicked.
Okay, nobody's kicking your ass. Carl, I think what you're missing is, I know you want the non-monetary stuff. And I'm telling you the way I believe I can achieve that is by having a settlement conference with the magistrate and having her put pressure on state police to agree to those non-monetary terms. That's what I'm telling you.
I hear you, but all that sounds to me is like, let's go. State police didn't agree to you begging for the crumbs that you want, the crumbs that they want to give you. Let's go ask the magistrate.
I don't know where it comes from because, again, I know we can go round and round, but I represented another person who got fired from the state police commission and publicly fired, like you, in a horrible, horrific way, and can't get a job. And the amount of money that they paid her was less than half of what they are offering you.
All right, I wish you would take the money out of your head, Miss Jill, because
I'm
not. Because look, you keep telling me stories about money. I don't. That's not my concern. That's not my concern. But if we're going to talk about money, and you know we're going to talk about 200,000, then okay, let's stop talking about that, because it's crumbs to me. That's crumbs to me. I just honestly, I'm not worried about who got what in the past or who did what in the past. That's not me. That's not my situation. I sympathize for them or with them, but that's not my situation. So what I'm talking about is the non-monetary. I'm not asking for much of shit on the non-monetary side. They got motherfuckers on the job who's
okay, Carl,
done way
right
worse
now,
of
they're
shit.
not agreeing to that.
Okay, and I'm not agreeing to that either.
Excuse me. To get you there, what I'm suggesting to you is we have an avenue to do that, and to do that immediately. And I hear you say it's not about the money, it's not about this, I'm getting my ass kicked, I want the non-monetary stuff, and I'm telling you I have a way that we can get there, and now you're telling me no. And then when you tell me it's not about the money, then you come back and say, well, no, that's crumbs. That's just crumbs money. And I'm trying to explain to you, based on my experience, no, it's not crumbs.
Yeah, it's crumbs to compared to the shit that's important to me. It is crumbs.
Well, if you want the shit that's important to you, like we've talked about, I'm explaining to you how we get there. Period.
Okay, I get that.
And that's what I'm trying to accomplish for you. Exactly what you want.
I get that, but I'm just saying the timing. We disagreeing on the timing of going to the magistrate
because Carl, I understand the litigation process, and you do not.
Okay, thank you.
I understand the danger of going to a civil service commission and you losing and having them deem your termination appropriate.
And
what that does to all of the rest of your claims.
Okay, I get that.
We've talked about that.
I get that. I get it. I promise you I get it. I get the avenue you want to take. I get it. But I'm just talking about the timing of it. And I heard your explanation of the timing of it and losing leverage. I get that. But I need time to think about that, because I just don't see, I just don't see why we need to rush and go to the magistrate right now as far as the leverage things go. If the magistrate is there, it's going to be there.
Well, you're going to have to trust me, and you're going to have to, I think, because I know what it means if you have a bad result in front of the commission and what that does to the rest of your case, it makes, as we talked about before, it kills it. If the commission concludes that your termination was in good faith and for cause, your only avenue at that point in time is to appeal that to the First Circuit Court of Appeal.
Correct.
And what's going to happen at that point in time is your federal lawsuit will be stayed or dismissed. Because if another body concludes that your termination was for in good faith and for cause, it doesn't matter if they were motivated by retaliating against Carl Cavalier. It doesn't matter. That is judicially going to stop the federal court from proceeding on your reprisal claims. That's the risk.
Okay, but
and that's my concern. And we've had these discussions.
So instead of taking risks, we just want to go and settle for something that's...
I'm not suggesting that we just want to go, Carl, but my job is to try to guide you in a direction that is sensible and that's in your best interest, and not fight for the sake of fighting.
No, I'm not trying to fight.
I want to go to the commission, Carl, but at the commission, there are significant risks for you.
Okay, I get that, and I appreciate that, but I'm not fighting for the sake of fighting. I'm fighting for the sake of, hey, these are not the terms that I'm agreeing to. Okay, and I get.
I'm trying to get you those terms, and you're telling me
no.
I don't want to hear.
All right, no, you keep cutting me off. I understand that in order for you to try to get me those terms, you want to go to the magistrate. I get that part. I'm just saying that I don't think that it's most effective that we run to the magistrate instead of just going through the commission. And I understand that if they rule against me, and it's likely that they will, because I don't trust them. I don't think they act in good faith. But
and then there is no magistrate, Carl, and then there's effectively no case.
Well, that's not true, because there's the appeals process, correct?
Now, Carl, the First Circuit Court of Appeal, please go look at those decisions, because I litigate there too.
Okay.
If you lose in front of the commission, your chances on appeal aren't that great.
So you're saying that appeals, they're gonna agree with the commission most likely? That's what you're saying? They're not gonna look at the case?
The majority of times, yeah. Go look at the court of. You can Google that. look, I've had them reversed before, but it's rare. That's what I'm telling you. These are all intangibles and risks that nobody can predict.
I got you. Well, as my attorney, I appreciate your 33 years of experience and giving me your advice on that. But I don't think that the risk I took and giving up, endangering my career, putting my career on the line, is me settling, for the terms that they want to come to, and just settling on some shit I don't agree to.
I got another client who's here. I need to go meet with her. I'm happy to sit down and discuss with you. I've given you my advice.
Okay.
And the answer is the risks for you are enormous.
Gotcha.
And honestly, the 4 things or the 3 things that you want, I'm telling you I can accomplish. You have to have a settlement conference no matter what.
Understood.
You are complaining you want those non-monetary things, and I'm telling you I have an avenue and a way to get there, and you're telling me I don't know if I want to do that.
No, I say I don't know if I want to do that this soon. That's what I'm saying.
And what I'm telling you is, from a leverage standpoint, you are in the best position that you will be right now.
Got it. Well, I digress for right now. I'll call you later about it.
All right.
All right.
Thank you.
Bye-bye.